If you will please stand for the Pledge of Allegiance. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you are not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. Have the commissioners had a chance to review last month's meeting minutes?
Yes.
Is there a motion regarding those minutes?
Move for approval. Second.
All those in favor?
Aye.
Motion passes. Billy, do I need to be voting since we only have 4? Okay.
3 on 5 because we have a quorum.
Thank you. First item on our agenda, we have a review of Smith Wrecker's emergency licensing amendment. Mr. Fields.
This is he has added his wife to the permit. He failed to do that under Tennessee law. She's already an owner, but and any time there's a change to the face of the permit, it has to be reported. I don't think it requires action. I think it just has to be reported to the commission.
All right.
So
it's so reported.
Thank you.
And next item, we've been asked to review new record driver permit applications for two individuals, Dwight Mason and Jason Small. Mr. Fields.
Mr. Mason? Mr. Mason's application was deferred from last month. He was asked to again attend this month. Mr. Mason, are you present? Does not appear to be present. This is his second appearance.
Is there a motion, Commissioners, regarding Mr. Mason's application?
Motion to deny.
Second.
All those in favor?
Aye.
Motion passes. And Mr. Small? Mr. Fields?
Jason Small, are you present? This is his first appearance. He had 2 issues he failed to disclose. We can defer him, or he's not present. He was notified.
Move deferral to the April meeting.
Second.
All those in favor?
Aye.
Motion passes to defer Mr. Small's application. Next item, we've got a new booting employee application for Michael Holdridge. Mr. Fields, you've provided his information.
I did. Mr. Holdridge failed to list 3 or 4 things. None of them would preclude him being from keeping and doing this particular job, but he failed to list them. They were all relatively old. Mr. Holdridge, you're present. He also was notified to appeal.
Is there a motion regarding Mr. Holdridge's application?
Move deferral to April meeting.
Second.
All those in favor?
Aye.
Motion passes. Next item on our agenda, we have new taxi cab driver applications for Mark Abu Rama and Mahari Faisal. Mr. Fields.
I think Mr. Fasil is here. Mr. Abu Rama? Not present.
What were the issues with Mr. Faisal?
Okay, he failed to it was a 2014 charge that he failed to list. It is listed in there as sell or buy and give alcohol to a minor. That was on 1/30/14. He failed to put that on his application. Mr. Fasil is available.
Hello, is it Mr. Faisal or Mr. Fazil?
Fasil.
Fasil. Do you understand why you were asked to come forward today? And why is that?
Yeah, I didn't know. I didn't put the charge on my application for taxi license, and thus I didn't know that was important for the license, and I made a mistake.
And I see that you have a representative from Green Cab here with you.
Yes.
You're already employed with Green Cab?
Yes.
I'll make a motion. Move for approval.
Second.
All those in favor?
Aye.
Motion passes. Thank you, Mr. Fitzgerald.
Thank you.
Next, we have other passenger vehicles for hire.
Mr. Chairman, do we need some action on Mr. Abu Rama? Do you want to defer, or?
You're correct. Is there a motion regarding Mr. Abu Rama?
Move deferral, April meeting.
Second.
All those in favor?
Aye.
Motion passes. Next item on our agenda is under other passenger vehicles for hire. We have a request by Daniel's Limousine Service to add Addis Gerberwitt and Zalim Fatini as partners.
Yeah. One of those things where in order, it has to, I do think you have to take action on this because it's to the certificate itself, but he just wants to add partners and it's in order.
I move to approve.
Second.
All those in favor?
Aye.
Motion passes. We also have some company application reviews. The first one is Advanced Transport Service. Fields.
Advanced Transport Service, Bob's, Changing Lanes, Transportation, Midtown Limo, and Nashville Black Car Transportation all made application, requires your action. All of them are in order.
Is there a motion regarding the application reviews?
I make a motion to approve all of them.
Second.
All those in favor?
Aye.
Motion passes. Next, we move on to horse and carriage items. First item is a review of a driver request from Nathan Redfern, which was deferred from February. Mr. Field.
You had heard Mr. Redfern was here at the February meeting to respond. He had failed on his application, and he had failed when he applied to disclose 2002 worthless check charges. Because of that, I had to ask him to come in. I also had to advise you that he was likely subject to complaint from several complaints about driving a carriage without a license. And you asked some questions, and then we deferred that and the complaint to do it all at this month's meeting.
Right. And then there's the next, I see the next item, we've got the actual complaint against Hatchery Carriage.
Correct.
Let's hear the complaint against Hatchery Carriage first, and then we can and then we can review Mr. Redfern's request.
This particular complaint was not generated by staff or the Metropolitan Police Department. It was generated by several drivers. I think they have a spokesperson who would present that complaint.
Mr. Chairman, members of the Commission, Gary Blackburn on behalf of these complainants who are associated with a competing company, Sugar Creek. The witnesses are here and are prepared to give this evidence. However, photographs have been submitted. I provide Mr. Fields with color copies of those. I think you had black and white. And if you'll recall, Mr. Redford was here last time and was asked whether he had operated a carriage without a permit and said that he had. I congratulate him for his candor. However, there was more than one occasion, and the materials that we have demonstrate that these pictures were taken on November the 29th and December the 14th. And These folks are here. I will be happy to call them as witnesses, but they would simply confirm what's said in the complaint and demonstrated by the photographs. And in the interest of time, I would suggest that that's sufficient to demonstrate the underlying truth of the underlying complaint. I have asked my client if there are any similar things that have happened in the past, excuse me. If you went all the way back to 2010, and this is in the minutes of the commission, there was a time when Sugar Creek was charged with a similar offense. There were 2 other matters which were contested. I'm not here to retry those. That's many years ago. One of them did have to do with the identical charge here, and the outcome at that time was a suspension of 3 months. It was originally proposed 6 months. That failed for want of a second, and there was a 3-month suspension. This is obviously within the judgment and the discretion of the commission. That's the only other similar one of which I have knowledge. There may well have been others, but I know of that one because it did involve Sugar Creek those years ago. And if anyone wishes for me to put on the proof, I will, but I think you've heard the facts. I don't think they're in dispute.
Is Mr. Redfern here today?
Yeah.
Ms. Redfern's here, and Sam Roberts from Hatchery Creek is here as well.
I would like to ask for a short delay. My attorney, oh, there he is.
I apologize for being late. I was coming from a parole hearing in East Tennessee. But I've been hired by Hatchery Creek to kind of assist with some of the confusion here and everything, and as far as the permit, and this is the application. Is that what we're currently talking about?
Actually, we're addressing Hatchery Carriage's complaint against
That's the complaint.
Sugar
Okay. Okay. As far as having,
excuse me, against Hatchery.
okay, as far as having a person who is not currently licensed holding the reins.
Yes.
Okay. So, basically the position on that is that there is an ambiguity into the rules regarding a horsemanship course. In the Metro Charter, it addresses it in the qualifications for an applicant provision at 12.54.130 subsection C5. It says that the commission can designate by rule the requirements of a horsemanship course to be completed by applicants. And then referring to the rules that the commission has established, it does refer to what I believe would be such a course. And one of those rules is Rule 6 for new driver training. And in that rule, among the things that a new driver is supposed to do is demonstrate proficiency under the direct supervision of an instructor on at least 20 rides without passengers, and then show proficiency under the direct supervision of an instructor with passengers for 10 rides. So there's sort of an ambiguity into the rules as far as, is this new driver training something that is supposed to go before a person is licensed or after, because the charter specifically says that the horsemanship course is for an applicant, which obviously would be for somebody who is applying for a permit but does not yet have one. Yet in the rule that is established pursuant to the charter, it says that it's only that the training is for a newly permitted driver. So I think that there's a conflict there. But I think there's certainly a reasonable construction looking to the charter, which obviously controls over the rules, that type of training in the horsemanship course is actually part of the application process. And that's essentially what Hat Creek was doing here. It was not simply a non-permitted driver driving passengers just on his own, but rather somebody who was under the direct supervision of a permitted driver, and Hat Creek was simply trying to satisfy the new driver training horsemanship course as contemplated in the charter. So certainly there could be different constructions of that rule, but there's certainly no ill intent to circumvent any rule, because I mean, as a practical matter, it wouldn't have made any sense to do that, to have two drivers driving and try to circumvent. I mean, it would make sense if they had a non-permitted driver driving on his own to try to get around the permit rule, perhaps. But as long as you already have a permitted driver on the carriage, then there's simply no advantage to the operator to having the additional non-permitted person driving as well, except to try to satisfy the new driver training provision contemplated by the charter.
I'm sorry, I didn't get your name.
Ben Rabin, I apologize.
Ben Rabin. And I'm presuming that Hat Creek does not dispute that Mr. Redfern was
had the reins without
had the
permit.
reins on these dates, November 29th and December 20th.
Sure, there's no dispute, picture of it, and they don't dispute that. They simply were under the understanding, based on what I read, that was not only acceptable but required under the rules in order for him to become established. So, if we can kind of clear this up, I think that they would agree to not do that anymore, and only do the horsemanship course once a person has received the permit. And we're not trying to argue that this is how it ought to be going forward, but simply to explain what was going on here, to simply argue that there shouldn't be any kind of punishment or reprimand, but simply that this was done in good faith. I'd also note that the way that the new driver training horsemanship course came to be was actually from a December 2010 meeting before this board, when there were some concerns about some accidents and people who weren't trained, and essentially the commission said, well, we need to make this horsemanship course to ensure we've got better drivers, and also we need to make sure that there's insurance liability established in case there is a problem, so that way the people can be compensated. And in fact, Hat Creek actually went out with the understanding that the rules were as I suggested. They actually went out and changed their insurance policy to include what they call volunteer drivers, who are basically applicants who have not yet gotten a permit, that are not yet actually employed. So they actually got insurance coverage to cover these people, because their understanding under the rules was that this was actually required, that applicants receive this horsemanship training before actually getting the permit.
What I'm reading here is, it says all newly permitted carriage drivers must complete a training program under the supervision of a qualified instructor or trainer prior to operating a horse-drawn carriage alone on city streets. Is
Absolutely.
that the sentence that you're...
That is absolutely the language, and I think if you look only at the Transportation Licensing Commission rule by itself, then that clearly, I agree, contemplates that it's only for a person who already has the permit. Mm-hmm. But if you go back to the charter provision, which controls the rules, says that the commission should designate a horsemanship course to be completed by applicants. And obviously, it's an applicant to get a permit, so that clearly contemplates a person who does not yet have a permit. So there's clearly a tension between the charter and the rules, and certainly the charter controls the rules. So that was the understanding that they had. I mean, but I certainly agree, by itself, the rule would clearly contemplate somebody who already has a permit. But simply to explain the tension here, and I've got a copy of the charter provision. I don't know if the commission is familiar with that particular provision, but again,
do you have the charter provision?
I do, and I have highlighted. I have numbers
Actually,
for
even this one says alone.
the board here. I've got 5 copies of
This
the
here,
phone.
all newly permitted
Pass that
carriage drivers must
down.
complete the
Certainly in the
training
beginning
program
it says that no person shall drive without a permit on the first page, but on the second page where I've highlighted is this part about the commission designating the horsemanship course. And I'd submit that on that second page, that is what empowered the commission to come up with this horsemanship course in the first place, that is the source of the authority for you all to make this horsemanship course, which I think is a great thing to have. But again, the charter contemplates that is something for an applicant to do. Then in other words, as part of your application, show that you've done this course, that you've had the supervision and that sort of thing.
1254.
So again, this is not to dispute what happened that day, but simply to show that there was no bad faith, and that no action should be taken against the operator or any individual. And if the commission wants to establish clearly that the horsemanship course is only for a permitted person, notwithstanding the charter, we don't have any problems compliance with that. Our position simply is that no discipline is in order, given what I think is a very reasonable interpretation of the different conflicting language.
What does that say? Develop, what is that?
So the new
Council,
driver.
I mentioned the insurance situation, how in the December 10, 2010 minutes, that was when the insurance part was added, and I've got a copy of just the page out of Hat Creek's insurance policy that adds the volunteer workers, and I could submit that as well so that y'all can just see that they have attempted to comply in good faith, because there'd be no reason for them to add that rider unless they in good faith believed that non-permitted applicants were actually required to be at least just to have the rein, not to be driving solo, but simply under the supervision, which is exactly what happened in this particular occasion.
I don't see Mr. Is his name supposed to be on this?
It's not. That basically is for all volunteer drivers. It's not for an individual person. It's the volunteer workers provision on the right half of the page.
Hang on, Mr. Rabin. Mr. Fields, is the new driver training, which is part of our rules, was this pre-existing to the charter rule where it says the commission may designate by rule?
No, it would have come after. The ordinance itself would have been done in 2002. It appears that this particular rule was done in 2010.
And I've got copies of the minutes as well that we can pass down. And this is in 2010, where the commission was talking about this problem of, we need new rules to deal with several incidents of runaway horses, reduce the risk of occurrences, also to ensure adequate liability for insurance. It's on the second page, and then on the third page, and it's just simply a copy of Rule 6, so we can see exactly when and why this rule was added. And I'd submit again that this was pursuant to the horsemanship course provision in the charter that the commission, I think, rightfully decided that we need to have some kind of training. And I think, unfortunately, again, there's just some confusion in my client's part about when exactly and how this was supposed to happen. He certainly appreciated, and it says in the record, I think all parties here agreed with having this. It was just the question is when exactly this happens, and I think that's all we've got here is just a legitimate kind of confusion between the conflicting provisions of when this is supposed to happen, but certainly no bad faith here. And there would be no advantage to the operator for doing this, because you've got two drivers up there instead of one, so they're not making any kind of profit or advantage by paying the extra money to add the insurance for these volunteer people, and to have two people up there rather than one.
Thank you, Mr. Rabin. Anything else?
Sorry. Thank you.
Mr. Blackburn?
Mr. Chairman, I would note that nothing in Mr. Rabin's presentation ever said that a driver could operate a carriage without a permit that had passengers on it. I didn't hear that. I may have missed it, but I didn't hear that in what was read by Mr. Rabin. And what you'll see in these pictures is that each of these carriages did, in fact, have passengers. And that's the difficulty. What you'll see is that the other person, presumably a Hat Creek employee, was turned facing the roadway, not facing the front, turned around having some discussion with the customers, and the unpermitted driver of the carriage was plainly then driving. It stated this was some sort of a training program. Perhaps it was, but that's not the means to train. The ordinance is absolutely clear, 1254-120. It says, no person shall drive or otherwise operate a carriage engaged in the for-hire horse-drawn carriage service unless he or she has a driver's permit. And then it talks about getting about qualifying. It says a person that commits an offense, this is subsection B, if he or she operates a horse-drawn carriage for hire in the metropolitan government without a driver's permit issued by the commission. And then it provides that a business commits an offense if it employs or otherwise allows a person to operate a horse-drawn carriage owned, controlled, or operated by the permittee unless the person has a driver's permit issued by the commission. The defense here apparently is that they didn't realize they were violating the ordinance. I would respectfully submit that that's rarely, if ever, a defense in a matter of this type, especially when the overriding controlling ordinance has been so plainly violated. It was mentioned that there was, they had insurance. I haven't read their whole policy, but I have some familiarity with how insurance policies work. This person, as described, was not a volunteer. I'm not sure what the policy definition of a volunteer might be, but he was not a volunteer. He was a person, by their own statement, in training for employment. There's been no discussions whether he was compensated on those 2 days for those events. But it is standard insurance law that companies will not pay for accidents caused by intended conduct or violations of the law, violations of ordinances. This is a plain violation of the ordinance. This would have been sufficient for we have a debate, as Mr. Fields knows, about whether these are criminal or civil matters based on how they're prosecuted. Whichever way it was prosecuted, it could have been prosecuted as a violation, a plain violation of this matter. Now, if that had gone first to a court and there had been a conviction, as there most certainly would have been because the law is clear and the pictures are clear, then you would be dealing with a company and an individual who has violated the ordinance. I'm not saying that Mr. Rabin is not correct in saying that they had some intent to train. But there is no training that would allow an inexperienced, at least as far as the evidence here is shown, or unpermitted driver to operate a carriage, take into his own hands the safety of the customers who are on that carriage, while another employee simply sits turned facing away from traffic. And that's exactly what has occurred. Now, fortunately, there was not any accident. If there had been an accident and a civil case arose out of it, the first thing that would be alleged was violation of the ordinance, making it negligence per se. That would have been the first thing that would have been stated in the pleadings. So I would respectfully submit that simply because someone has a justification in a plain, unmistakable, unequivocal violation of an ordinance does not mean that that's a defense.
Thank you, Mr. Blackburn. Mr. Fields, could you remind us what are the potential penalties if we decide there's a violation?
I think the ordinance it specifically says under the disciplinary actions, you have the option of probation, suspension, revocation of the certificate of necessity. It's at 12.54070.
Well, I don't get to make a motion regarding this matter, but just when I review the facts, which do not, which I find that are not disputed, it appears based on the photographs and based on the admission of Hat Creek that Mr. Redfern was in control of the horse carriage. The driver who was, or instructor who was with Mr. Redfern was also in the carriage but not holding on to the reins, and at least in these photographs was turned around speaking to the passengers. And it is undisputed that Mr. Redfern did not have a permit at the time that he was driving the carriage on the occasions that we have before us, which is November 29th and December 20th. My review of the rule, respectfully, it's clear to me that only newly permitted carriage drivers are allowed to go through new driver training under our horse-drawn carriage rules. And even in those instances of a newly permitted carriage driver, they must be under the direct supervision of an instructor trainer on at least 10 rides with passengers. And these photographs indicate that Mr. Redfern was not under direct supervision, given that the instructor was not holding on to the reins or looking at the road while Mr. Redfern was driving the carriage. So I would think that Hat Creek is in violation of the rule that we have before us.
Well, the charter allows for establishing a horsemanship course. The commission did that, and the Rule 6, it says all newly permitted carriage drivers, and it doesn't say all potentially permitted carriage drivers. It says all newly permitted carriage drivers, and therefore, in my mind, I find a violation of Rule 6 by Hat Creek Carriage.
I concur with you both.
You want to make a motion?
Go ahead, Sam. And this is just for the finding of the violation.
Correct.
Well, I find Hat Creek Carriage in violation of Rule 6 of the Transportation Licensing Commission rules related to horse-drawn carriages.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Now we should consider how we address the violation of the rule with Hat Creek. And Mr. Fields has informed us that we can put the company on probation, we can suspend its permits for some period of time, or we can even revoke the permit.
I move 30-day suspension, 1-year probation.
I second.
All those in favor?
Aye.
Motion passes. Mr. Fields, I think that concludes the complaint. Now we have the driver request permit request from Mr. Redfern.
Mm-hmm. One clarification, is suspension begin immediately?
Effective immediately was my intent.
Yes.
Without anything, that's what I would have taken, so. Okay. Mr. Redfern has made application. He appeared last month, and again, as just we mentioned earlier, he was deferred. He failed to list a worthless check charge from 2002 was the only thing that he failed to. Everything else was in order in his application.
Is there a motion regarding Mr. Redfern's application?
Make a motion to approve the application effective 30 days from today.
I second.
All those in favor?
Aye.
Motion passes. Now we've got one last item. We've got some requests for additional downtown carriage operation permits from Cumberland Carriage, Hat Creek Carriage, and Sugar Creek Carriage.
All three are present. Three companies this year, Capital Carriage, Keith Carriage, and Southern Elegance have not renewed their permits, which means there were three carriages open, three carriages that had been operating. Now, I believe that Southern Elegance has not operated during this last year. They actually began the process of renewal last year and did not fully renew. So two of these have not been operated two of these have been operating for the last year. The other one had not. So in reality, there are two places where carriages have been. I invited Diane Marshall, who is, I'm going to make her the executive director of the Traffic and Parking Commission. I suspect she would deny that. But she clearly is she works with us on carriage stands and other issues related to all of our stands. And I've asked her to be here to talk about to answer any questions you might have about the number of stands and availability and any other issues you might have related to traffic.
And how many permits are being requested by each of the companies?
Cumberland has for 2, Hat Creek 1, Sugar Creek 1. But without asking, they would take all we would give them. I know them well. Cumberland Carriage's request goes back to probably 2003 or 4, I suspect.
May I ask Ms. Marshall a question? Main question, this is downtown. Downtown's growing. We've got a lot of automobiles, Ubers, taxis going through there. Is there an idea of how many horse-drawn carriages, traffic and parking sees that the city can support?
Currently, we only have 4 locations designated for horse-drawn carriages. 2 of those are on Broadway, and 1 is on Commerce, and 1 is on First Avenue.
Does that mean they can only operate those 2 at that time?
Those are the locations that are signed as carriage stands.
Do you know the capacity of those locations roughly in length? Or
The one on First Avenue would perhaps handle 4 carriages. The one on the north side of Broadway would be 2 or 3. The one on the south side of Broadway would be 1 or 2. And the one on Commerce would be 1.
Is each carriage limited to a certain area?
No, they are not.
They're not.
But they are required to use the routes that you guys designate, correct?
There is a designated route for them.
Okay.
How many existing carriages?
At the present time, the operation, Cumberland Carriage is operating 1, Hat Creek is operating 3, Southern Comfort operates 4, Sugar Creek operates 4.
Given that we have 3 companies that have not renewed, I don't see a reason why we shouldn't approve these for permits.
Well, I guess my only concern is we have these carriage stands, and if they're filled to max capacity and another one decides to come in, is there any rules or regulations that only that many can operate out of that stand just to ensure?
Typically, what we've operated off of is a belief that we needed at least half capacity on all the stands to accommodate the carriages. Anything above that would be, in other words, half out on the street and half parked. Again, I think the companies, that seems to be the tendency of the way it works. They're typically not all parked at the same time. Based on Ms. Marshall's minimums, you would be able to park 8 carriages, which would put the other 6 out on the street.
Okay. And how many do we have right now, even with the companies that did not renew? Or
you would have 12 with the ones that are not operating right now. I mean, that are operating right now.
So they've bumped the number to 16 if we granted all 4.
$16, and we have space for between 8 and 10.
That's a rough estimate,
Rough.
yes.
Okay.
And the stand on First Avenue is the only one that is designated for daytime operations.
Are there? I'm sorry. Go ahead and tell.
Does it gets shut off, and the Broadway gets shut off?
Anytime there's special events, yes, those stands are taken out of service.
Okay.
Are there any plans to develop additional stands for carriages?
Miss Marshall and I, not to speak for her, but I think I can on this one, we meet on a regular basis looking for additional ways to accommodate carriages, taxi cabs, and any of the conveyances that we're responsible for. The challenge is that it is a great challenge downtown. I think everybody recognizes that, but we're looking. I have no proposals to bring to the commission to take to the Traffic and Parking Commission yet.
Are there other locations besides downtown that carriages are permitted?
They could go to other places. What would happen is we'd work with the commission staff as well as the traffic and parking staff to determine where they could go. And we've certainly talked with the companies about that, whether if they wanted to operate in other parts of town.
Can we take these up separately? We have requests from Cumberland for 2, and
one for Hat Creek.
One for Hat Creek and one for Sugar Creek. I guess we should do them separately. I move 2 additional permits for Cumberland Carriage tours.
I second.
All those in favor?
Aye.
Motion passes.
And we can choose to take no action on the others, or to grant.
It's entirely up to the commission has this authority.
I don't know.
I make a motion to grant the other 2. Grant 1 to Hat Creek and 1 to Sugar Creek.
I'll second that.
All those in favor?
Aye.
Motion passes.
There's no reason to do that.
All right, so that concludes our agenda today. Is there any other business, Mr. Fields?
I have no additional business to bring to the commission at this time.
All right, is there a motion to adjourn?
So moved.
Second.
Motion passed. Or all those in favor?
Aye.
Motion passes.